Hey, good afternoon. My name is Rebecca Sem. Thank you so much for attending today's webinar. Today, we're going to be discussing planning for incapacity. And so I'm going to first walk you through what I plan to discuss today and what to expect during this webinar. Okay. Whoops. Little technical difficulty there. Sorry about that. First, I'm going to introduce myself and what my background is. Then we're going to discuss what incapacity is. It's obviously a very broad topic, and there are different measures of incapacity. So we'll take a moment to discuss what some of the legal definitions of incapacity are. Next, we'll discuss how you can plan for incapacity using a revocable living trust. Then we will talk about the use of a durable power of attorney in order to plan for incapacity, and also planning through an advanced healthcare directive. We'll discuss how you can amend or terminate the documents once they have been executed. And lastly, we'll discuss what will happen if you fail to plan. And then at the end, I'll take your questions. So if you have questions as we go along, please feel free to type out your questions or wait to the end, and I'll be happy to take any questions that you may have. Before we get started, please let me know if anyone's having difficulty with the audio or video. And if I don't see there being any. Okay. I don't see there being any issues, so let's go ahead and move forward. Thank you very much. Okay, well, this is obviously me. My name is Rebecca Harrison Sem, and I am an attorney at law at the Kroloff Law Firm in Stockton. My area of practice is primarily in trust and estates litigation, which means that I often represent clients in disputes involving trust and estate matters, such as incapacity or lack of capacity, undue influence, elder abuse, breach of fiduciary duty by a trustee, etc. So I have extensive experience dealing with estate and trust matters, including issues related to incapacity. Also, I have experience dealing with incapacity issues and capacity planning, including preparing the types of documents that we're going to discuss today. And I also am an adjunct professor at Humphreys University Drevon School of Law, where I teach wills and trusts. So that's a little bit about me, and just wanted to introduce myself to all of you. Okay, the first thing we're going to discuss today is some of the legal definitions of capacity as defined in the probate code. Now, often when I have clients that come to my office and want to execute testamentary documents, such as a will or a trust, I have to ensure that that individual has the competency to execute those documents. So I will then refer to this legal standard and see if the client is able to make a testamentary decision. So probate code section 6100.5 defines testamentary capacity as an individual is competent to make a will if they can do any of the following. Okay, first, they must understand the nature of the testamentary act. So what does that mean? It means that they understand what it is that they're doing. They understand that the document that they're executing is testamentary in nature, and that they are there to sign a will or a trust. And they know that's what they're doing. Secondly, they must be able to understand and recollect the nature and situation of their property. So this means that they must be able to recall what it is that they own and who owns it. So I will often ask the client to tell me what their property is and what their ownership interest is in that property. Now, does this require that they are able to tell me account numbers and parcel numbers of property? No, they just have to have a sufficient understanding that the property that they own, that they understand the nature of the property that they own. And lastly, they must be able to understand their relationship to their descendants, spouses, and other living relatives who may be affected by the will. So I will ask the client to tell me how many children they have, are they married, what is the name of their spouse, etc. So I can be confident that this particular individual knows who is the expected beneficiary under their estate. So if I'm confident that the client can meet these 3 requirements, then I will feel comfortable moving forward with preparing their estate plan. Now, if I have some concerns, certainly I would recommend not moving forward, and then perhaps they would have to take another approach to, as we'll discuss later, if they want to, if they need to have some testamentary documents put in place. Okay, moving forward, there's also the legal mental capacity. And this standard governs the more higher level cognitive functions that would be required for entering into a contract or other types of decisions. Now, so the standard that we discussed earlier, the testamentary capacity standard, is a lower standard than this capacity standard. So under this probate code section, the individual has to demonstrate a higher level of cognitive functioning. So under this standard, a determination that a person is of unsound mind or lacks the capacity to make a decision or do a certain act shall be supported by evidence of a deficit in at least one of the following mental functions. So the code looks at 4 different aspects of mental functioning to determine whether there's a deficit. And there has to be a deficit in at least one of these areas. Okay, the first area is alertness and attention. Is the individual, are they sufficiently aroused mentally? Are they oriented to time and place? Can they tell you where they are and what day of the week or the month of the year? Are they paying attention? Are they able to track the conversation and concentrate on what is being discussed? Secondly, the second aspect is information processing. This is the ability to remember details, to recall information, and to be able to communicate those information to another person. Furthermore, it's also deals with reasoning and logic. So information processing covers memory and reasoning and logic. Third is the thought process. This is what we often consider as having a disorder that may affect your thought process, such as delusions, schizophrenia, disorganized thinking, etc. The individual is unable to organize their thoughts, or they are subject to delusions or hallucinations. And then finally, the individual would be considered legally incompetent if they're unable to modulate their mood and affect. So what this means is the mood is not appropriate in degree to the circumstances. So you might have someone who is anxious or nervous for no apparent reason, or they're angry and there's nothing that would be evident to cause that person to be angry at that moment. So if one of these 4 deficits are shown, then it's they could be determined to be of unsound mind or lack mental capacity. Okay, so why is this important? Well, okay, before we move on, so one of the major causes of incapacity is dementia. And dementia is the umbrella term used for the loss of memory or thinking abilities that interfere with everyday life. And so dementia is often used interchangeably with Alzheimer's disease, but there's actually Alzheimer's falls under the umbrella term of dementia. There's actually multiple types of dementia, and they range in severity. So just because someone has dementia does not mean they have Alzheimer's, but if they have Alzheimer's, then they do have dementia. So I just want to be clear that the term Alzheimer's is an umbrella, falls under the umbrella of dementia, but is not synonymous with dementia. It's just a form of dementia. Okay, so under the probate code, people often think that a diagnosis of dementia automatically means that the person lacks the mental capacity to either testamentary capacity to enter into a trust or to execute a will or to execute a contract. However, just the mere diagnosis of a mental or a physical disorder is not sufficient in and of itself to deem a person that they lack capacity. So individuals are deemed incompetent, are presumed to be competent until it's shown otherwise. So it's not just a diagnosis of dementia that would render someone incompetent. Okay, so now we're going to move our discussion into ways that you can plan while you're healthy and of sound mind to prepare for circumstances that may occur later on. One of those may be dementia, and maybe an accident or some other medical condition that would cause you to be unable to satisfy those legal requirements to make a will, a trust, or to sign a contract. So you want to be able to plan early on to, in case the unfortunate or inevitable occurs where you or a loved one is unable to make those decisions. So I'm going to be discussing some instruments that can be executed during a period of time when you do have the requisite capacity that can help prepare for if things were to change down the road. Okay, so the first document I'm going to discuss is a living trust. So the question that raises is, what is a living trust? Why would I need this document? Well, a living trust is a legal document or a trust that is created during an individual's lifetime, where a designated person, who is the trustee, is given responsibility for managing that individual's assets for the benefit of the eventual beneficiary. So during the lifetime of the trustor or the person creating the trust, typically the person who is deemed the trustee are the people who executed the trust, usually a husband and wife, and they'll create a trust, and then oftentimes will act as co-trustees. And the trust will name a successor trustee who will then step into the shoes of those of the original trustees should they become incompetent or unable to serve, or of course upon their death. So let me talk a little bit more about living trust. Okay, so I think there's often confusion about the difference between a living trust and a will. When it comes to estate planning, a living trust is a very useful tool to avoid the probate process. So what that means is that the trust is, if there's a trust put in place and the assets are sufficiently transferred into the trust, then this will avoid the need for a probate to be opened upon the death of the trustor. Now, this is a very important purpose for a living trust, because probates can be very time consuming, they're expensive, and they can take a long time to administer. Furthermore, you have to go through the court system, and the courts have a say in some of the decisions that are made. Now, under a will, you have to probate the will with the court, meaning that after the death of the person who created the will, their named executor must file a probate with the probate court and have it an executor appointed, and then go through the process of administering the estate through a probate. Again, that is a very time-consuming and expensive process that most people try to avoid. Furthermore, a living trust allows for the private administration of assets. When you file a probate action with the court, it becomes public record. Anyone can access those records online or at the courthouse and see what the estate holds and who owes what, and all of your private financial affairs are out in the open. However, with a living trust, it largely remains out of the courts, and it remains private, and it's not something that the public would have access to. And then lastly, one of the advantages of a living trust, which I'm going to discuss today, is that it allows for incapacity management. Since the living trust is a living, breathing document, and it's operative during the lifetime of the person who created the trust, that means you can plan for your incapacity with a living trust instrument. Conversely, a will is only effective on death. It has no legal effect while the person is still alive. Therefore, it doesn't allow for any capacity management or incapacity management since it only becomes effective on death. Okay, so how are you or individuals able to plan for incapacity using a living trust? As I mentioned before, a living trust allows you to name a co-trustee or a successor trustee. Many married couples will create a joint trust in which they are both named as co-trustees. So through this, if one of the spouses becomes incapacitated or is no longer able to serve, the co-trustee can serve alone and has the power to continue managing the trust seamlessly without any need to get a court order, have any documents executed. For the most part, it's an easy way for a spouse to take control if one spouse is no longer able to serve. Now, in addition, you also can name a successor trustee. This person is often a trusted friend or family member who will serve in the event that both spouses either are unable to serve due to incapacity or pass away. So the successor trustee will step in the shoes of the original trustees and manage the trust and distribute the assets according to the terms of the trust. So this provides for a seamless transition from the originating trustees or the named trustees to a successor should incapacity occur. Furthermore, a trust gives the trustees or the settlors the ability to determine how incapacity is assessed. Now, this may seem puzzling because incapacity would appear on the surface to be something that would have to be determined either by the court or by a medical physician. Now, and that would be the choice of the settlors. You can place in your trust when the successor trustee or co-trustee is able to serve alone. Is it upon a medical doctor's determination of incapacity? If that's the case, then you would need to get a written document from your doctor who attests that the person is no longer capable of managing their affairs, and the successor trustee can then take over at that point. Or if another way you could do it is you could have the beneficiaries of some group of individuals who are benefited by the trust make a decision for the family if they believe that a family member is or the trustor is no longer able to manage the trust. So there is a way to craft how the transition of authority is made, and you have the ability through this instrument to make that determination. And as I said before, it provides for an easy transition of authority. Once the trustee or the settlor is deemed to be incapacitated, the successor trustee can step into their shoes and take over and start managing the assets. And then also what's nice about a living trust is that it allows for the management of a wide array of assets. So for example, you can, all of your real property holdings can be placed in trust, your bank accounts, your investment accounts, a wide variety of assets can be managed through a living trust. And that way, if there is the unfortunate circumstance where the trustee is no longer able to serve, then a lot of a person's wealth can be managed through a trust, and that successor trustee can come and begin managing those assets. So a trust can be a very effective way to plan for incapacity. But the trust is not without limitations. So it's an important aspect of incapacity planning, but it's not the entire picture. It doesn't cover every single scenario. So there are some decisions or acts that are not covered under a trust, living trust document. For example, it doesn't govern healthcare decisions. So your trust document does not dictate who will manage your healthcare decisions should you become incapacitated. Furthermore, there are certain financial decisions that aren't covered by a trust document. This can include private bank accounts that are not in the name of the trust. It can include other types of taxes, dealing with assets that for whatever reason aren't included in the trust document. And so it also allows you to manage those non-trust assets. So you cannot use a trust to manage non-trust assets. Also, the trust doesn't give you authority to speak on behalf of the trustee related with dealing with any governmental agencies. For example, if the successor trustee needs to contact the IRS to discuss a tax issue, if it's related to the individual's own personal taxes, they will not have authority to talk to the IRS or any other governmental agency on behalf of the individual. And they will not have authority to put assets into the trust if they're in the name of the individual. So if that could be detrimental if the trustee is unable to take assets that may come into ownership by the individual and transfer them into the trust. And lastly, the trust often doesn't allow for the trustee to make arrangements for the personal care of the individual, of the person who is incapacitated. So while a living trust can be a very useful tool in planning for incapacity, there are some limitations on what a trust can cover. However, there are ways to to protect the individual for the types of situations for which a trust does not cover. Okay, the first type of instrument is called a power of attorney. And this document's often referred to as a POA. A POA is a legal document in which you, the principal, designates an individual, the agent, to act as their attorney in fact, with broad powers to manage financial, business, and legal affairs. The agent also owes a fiduciary duty to act in the principal's best interest. So in a power of attorney document, the principal names an agent. Oftentimes, if you're married, you'll name your spouse. You may name your child or a close friend or trusted advisor who will step in your shoes and act as your agent to help manage your financial, business, and legal affairs. And this largely governs the types of transactions that aren't governed by the trust instrument. So in addition, the agent owes the fiduciary duty. So every transaction they enter into must be for your interests. They cannot serve their own personal interests or act in a way that serves them, their needs over yours. So they're bound by a fiduciary obligation to serve your best interests. Okay, so what types of powers does an agent have under a power of attorney? Now, these are powers that are often included. They're not exclusive, and they can be amended to either include or to be deleted from a power of attorney. They do not have to be included in each document, but these are often the types of powers that a durable power of attorney will provide the agent. First, it's to sell, encumber, or lease real property. Well, you might be thinking, wouldn't the trust hold my real property? Well, there may be pieces of property that you own outside of the trust for whatever reason. And if that's the case, or you may not have a need for a living trust because the amount of your holdings is so small that a trust wouldn't necessarily be required. So this power of attorney would give your agent the power to or authority to sell, encumber, or lease real property. It could also allow that person to control partnership interests. So if you are a member of a partnership, or you have you're a shareholder of a corporation, a member of an LLC, etc., that person would have the ability to make decisions regarding your interests in that entity. And also to purchase or sell stocks and securities. That person, the agent, would be allowed to collect debts on your behalf or pursue litigation if it's determined that the need should arise, that you would need to pursue litigation. The person would have the ability to do that on your behalf, pay debts, sell or transfer personal property. So, for example, most people don't place their motor vehicles in a trust or transfer title to the trust. So if the agent needs to sell a vehicle, the power of attorney would give them the authority to do that. As I mentioned before, prepare and file income tax returns for the individual, which you wouldn't have the authority to do under a trust. Manage checking and savings accounts, invest their funds, deal with government agencies such as the IRS, Social Security. And also, what's an important component of this power is often when an individual becomes incapacitated, they may need long-term care. And long-term care is not covered by Medicare generally. So it may come a time where the agent may have to apply for public assistance through Medi-Cal to qualify for long-term care. So this power of attorney would give that person authority to make that application with the government. And then also just generally hire healthcare providers and provide for food, clothing, and shelter, and other acts as needed. Now, this may seem like an exhaustive list, and it is. What's nice is that the principal, when they create this document, has the ability to craft it to serve their needs. I think the important thing to remember is that this, if this POA is used in the event of an incapacity, you want to make sure that you provide for all scenarios that you think might occur in the event of your incapacity and what that person would need authority to do. So in that sense, it's good to have broad powers to allow for that person to make decisions for you. However, with broad powers comes the fear that perhaps the person might not act in your best interests. So if that's a concern, then you can put some limits on their authority. But the purpose of a power of attorney is to avoid having to go to court and get powers to make certain decisions. So it's important to choose someone that you trust and that you could be trusted with the broad powers that's given to them under this document. Okay, so to I guess expand on the topic of POA, there are two types. There's several types, but there are two main types of POAs that can be executed. One goes into effect immediately, and this is what you generally refer to as a durable power of attorney. So as soon as the document is executed, your named agent has the power to immediately to act on your behalf. Now, there's pros and cons to a durable power of attorney. The pro is, and this is especially true for spouses, is that that person can act immediately, and if in the event of someone's out of town traveling and needs to sign some documents, then they would have the ability to do so. But on the flip side, it could also allow for someone to access your property and funds immediately, even before capacity occurs. So, but for the most part, having the ability for them to act immediately can be useful, because then you don't have to make a determination of incapacity should that person need to step into the shoes of the individual. Now, if you want to wait and have your agent only be able to serve once you're deemed incapacitated, then you would want to execute what's called a springing power of attorney. And a springing power of attorney only goes into effect upon the incapacity of the principal. So up until that point, the agent doesn't have authority to act. They only can act upon the incapacity of the principal. So again, it's your choice to decide which one would work best for you, and also your choice of agent may drive how you want to execute the power of attorney, if you want it to be immediate or upon incapacity of the principal. Sorry about that. Okay, so there's also another type of power of attorney that is part of what you would need to think about when you're planning for incapacity. And this is what's called an advanced healthcare directive. Now, advanced healthcare directives is a tool that allows healthcare wishes to be known when a patient is unable to communicate. It also allows you to appoint a healthcare agent and give specific instructions for future healthcare decisions. So the trust in the power of attorney that we discussed earlier does not give the agent authority or the trustee authority to make healthcare decisions. So this document is the document that would allow that agent named in that document to make decisions, healthcare decisions. Now, it can be crafted so that you can make your wishes known and help guide the agent for decisions that need to be made later on that might be difficult for them to make. And also you can include quality of life information, and also you can indicate your choice of treatment. Which is intended to guide the medical team and support your surrogate. So I think on end-of-life decisions, having your choices indicated in the document is going to give the agent a lot of peace of mind. And also, the healthcare agent has the power to interpret the document for the medical team according to the circumstances. And in addition, the healthcare directive often includes what's called a HIPAA waiver. And HIPAA is the series of privacy laws that protects your healthcare information. And in order for your agent to access your healthcare records, they would need to have this HIPAA waiver in the event, along with your advanced healthcare directive. Okay, so the next section I'm going to discuss is how can I amend or terminate documents once they're executed? So say you've made the decision to plan for incapacity. You've created a living trust that covers most of your large material assets, such as your real property, your bank accounts, your investment accounts. You also have a power of attorney that governs any transactions or decisions that are not covered by the trust. And then you have an advanced healthcare directive that covers your healthcare decisions. So there are, especially if you execute these documents at an early phase of your life or even later, things happen and you may need to change those documents or terminate them altogether. What's nice is that revocable living trusts are completely amendable and revocable. It's just important that you follow the procedures in the instrument for amending or terminating the trust. A failure to do that may cause the revocation or amendment to be deemed invalid. So it's very important to follow the procedures in the instrument or any statutory procedures that may be in place in lieu of the procedures in the trust. So if you want to amend or revoke your living trust, refer to the document for the correct procedure as to how to amend or terminate those documents. With a durable or springing power of attorney, you would want to execute a revocation or amendment in writing that's signed by the principal. What often prompts someone to want to revoke or amend their power of attorney is perhaps their agent has been mismanaging their acting out of the best interests of the principal. And if you're concerned that the agent may still continue to use that power even after it's been revoked, it's recommended that you distribute the new power of attorney or the revocation to any known financial institutions or other entities if you're concerned about fraud. So you want to make sure that banks and other financial institutions are made aware of the revocation or the appointment of a new agent. And same is true of the Advanced Healthcare Directive. If that's amended, that will need to be in writing, signed by the principal. And you'd want to distribute these any of these changes to your healthcare providers, so to ensure that they have the most recent version of your Advanced Healthcare Directive in their records. So our last topic is, so what happens if you fail to plan? So if you decide that, okay, I don't think I need to, I'm healthy, I don't need to plan for incapacity, I'm just going to roll the dice, so to speak. Well, what if something were to happen to you? That really puts your family and loved ones in a tough situation, because they're going to need to make decisions for you that they're not going to have the authority to do. So if in the event that there is no trust or POA or Advanced Healthcare Directive in place, and medical, financial, or decisions related to the trust need to be made, they must turn to the courts for authority. And the procedure that is used to obtain authority to act on behalf of a person who may not be able to manage their own affairs is called a conservatorship. Now, a conservatorship is a court proceeding that is meant to protect a person who cannot care for their own person or property. Now, there are many reasons why conservatorship might be put in place. It's not always just incapacity. It could be because someone is unable to manage their own affairs. But it often is used when someone loses the ability to manage their affairs through incapacity, and they need to have someone appointed to manage their affairs. So a person would have to petition for conservatorship. Obviously, it would be someone who would have the standing to file the papers, nominating a conservator who will make decisions for the conservatee and act in their best interests. The court may establish a conservatorship of the person, the estate, or both. Now, a conservatorship of the person governs that person's basic needs. Okay, their food, their shelter, their making sure the person is cared for and fed and clothed and sheltered. And the estate manages their financial affairs, or both. So the court can appoint a conservator of the person, of the estate, or both. In establishing a conservatorship of both, they may appoint a separate conservator or a person to serve in both roles. So why is this something that you should try to avoid? What's the drawbacks to conservatorship? First and foremost, it gives the person loses control over key decisions. Someone else is making decisions, and that person may not be the person that you want making decisions for you. So you not only the inability to perhaps make key decisions, or to have someone make decisions for you that you might not have selected. Again, just like with a probate, there's the time and expense of court proceedings. Conservatorships are expensive, they're time consuming, and they require accountings if there's a conservatorship of the estate, court investigators. It's a very lengthy process. A conservatorship can create additional stress on family members and friends who have to deal with the court process. That's hire attorneys, have documents drawn up, and it can be very stressful. And furthermore, many decisions that Advanced Healthcare Directive or a POA or a trust would allow the person to make without court approval would require the approval from the court. So the court has more oversight on a conservatorship than they would any other of the documents that we talked about today. So a conservator may have to go to court and get approval to make certain decisions that otherwise would be governed by the documents we covered today. Okay, so we've talked in great detail about what types of documents are recommended for incapacity planning. So what are the recommended next steps? First, I think it's important to discuss incapacity planning with your family and friends. I know it's an uncomfortable topic to discuss with your loved ones, but I think given the increase in the number of people suffering from dementia, it's always important to think about these and plan for these things that might happen in the future. So discuss this with your family and friends, and start to formulate who you think might be a good candidate to be named as your agent or successor trustee, and could be trusted with managing your affairs in the future. And that would be assessing, obviously, those who are best suited to serve as trustees or agents. Next, I would recommend that you meet with legal counsel to formulate a plan that best suits your needs. Now, the documents I discussed today aren't one size fits all. They need to be specially crafted to suit your individual needs. So it's important that you meet with legal counsel who is experienced with preparing these types of documents and can counsel you on the best types of best plan for you moving forward. And then once you have your incapacity plan put into place, it's important that you keep it up to date. If there are changes to your property, or if you want to, or perhaps someone you've named as an agent no longer wishes to serve or may predecease you, you want to make sure that all of those items are kept up to date, because if you don't, then it could render your prior planning ineffective, and that's not what you want. So with that said, I want to thank you all for attending today's webinar, and I'm available to take any questions. Okay, one question is it a good idea to set up a POA while you're healthy-minded? Yes, I think that's sort of the what I wanted to drive home today. It's the best time to set it up is when you're healthy-minded, because like I said in the beginning of my presentation, if you're deemed to, once you've lost, if you become incapacitated, then you're not able to execute those documents any longer. So it's important that it's set up while you're healthy and of sound mind. So good question. Any other questions? Who will determine when you are incapacitated? Good question. Okay, often it's a physician who does what's called a capacity declaration, and they assess using many of the same standards that we talked about earlier about your attention, your affect, and they looked at all your memory, and they test you for that to determine if they believe that you're capable of making your financial decisions. Now, also, a court may order that a physician be that a capacity declaration be completed. So typically it's a physician that makes that determination. Now, certainly if a person comes to my office wanting to execute documents, and I have to make an assessment myself of if I believe that they have the ability to make those decisions and move forward accordingly after asking a series of questions. Okay. Any other questions today? Well, I really enjoyed having this meeting with you. My contact information is here on the screen. I can be reached at rsem@croloff.com. And my number is 209-478-2000. I'm happy to answer any follow-up questions that you may have. And I hope today's webinar was helpful to you and useful. And if you have any questions, please feel free to give me a call. Okay. And if there's no further questions, we'll stop there. Thank you so much, everyone. Have a wonderful day.